Henry. Ms. Aldea. Good afternoon.
Good afternoon. May it please the Court, I represent the people of the state of New York. Your Honors, I'd like to reserve 3 minutes rebuttal time.
Certainly.
Okay. Thank you. The Appellate Division erred in this case in applying a per se rule and in holding that counsel was ineffective. As a preliminary matter, the Appellate Division's decision makes it clear that it did in fact apply a per se rule in determining this claim, which is in direct contravention to this Court's repeated admonitions that in evaluating an ineffective assistance of counsel claim, reference needs to be made to the totality of the circumstances, and per se orthodoxies are in general disfavored. In this case, per se rule was not appropriate, and for that reason alone, the Appellate Division's decision was incorrect. In terms of the correct standard that should be applied, this case presents
too long ago.
And why should we?
I'll answer both of those questions.
I think there were 3.
First, Your Honor, in terms of this Court's decision, this Court has never actually made a decision as to whether Strickland should be adopted as a matter of state law. The question has been left open for a number of years, and this case presents the Court with the opportunity, one way or another, to decide the issue once and for all. Why should the issue be reached in response to the second question? The issue should be reached because in Benevento's wake, the Appellate Divisions have begun to misinterpret what the state standard actually is. Instead of reading Benevento as showing that New York has a separate prejudice requirement, although that requirement may be defined differently than it is under Strickland, the Appellate Divisions have read Benevento as abolishing a prejudice requirement altogether. And the danger in that is that it leads to decisions like this one. It leads lower courts to, instead of evaluating the totality of the circumstances and determining prejudice under any standard, they simply apply per se rules.
Well, that still doesn't suggest that there's anything wrong with the test. What's wrong with our test?
There are several things that do suggest something at least wrong with the reasoning that the Court has in the past employed to reject adopting the Strickland test. The first of those things is that, in general, the reasons given by this Court to not adopt Strickland, and the criticisms generally levied against Strickland, in this case by defendants, are that the Strickland test is too harsh and that the Strickland standard places undue emphasis on the outcome of the trial rather than on the inherent fairness of the process. But recent decisions show that this is simply not true. The first decision that I'd like to direct the Court's attention to is People v. Flores. In Flores, this Court held that counsel was not ineffective, in spite of the fact that he waived a potential Rosario claim that could have entitled him to a new trial. In its reasoning, this Court stated in Flores that it cannot be said that a defendant has any substantive right to be vindicated, and there is no basis in law or logic to order a new trial when there is no new issue to be tried. Conversely, on habeas review, the Second Circuit held that in Flores, the defendant was deprived of the effective assistance
And that
of counsel.
was, of course, on an enlarged record that indicated the incompetence of counsel, didn't it? That wasn't necessarily apparent when we had this on a direct appeal, right?
Yes,
so
Your Honor.
That doesn't quite make it, does it, in terms of showing that Strickland can be a sounder standard?
Yes, Your Honor, it does. I do recognize the difference, the distinction. However, although this Court's decision was based on the performance aspect, and in holding that in that case there was a tactical decision, there was also some dicta by this Court, which I just read, that related to the prejudice aspect. And this Court's evaluation of prejudice was ultimately concerned with whether the result at the second trial would be different than the one in the first. On the other hand, conversely, the Second Circuit, in finding counsel ineffective, had to address both performance and prejudice. They not only disagreed with this Court's finding on performance, which was based on the new evidence that was before them, but they also disagreed with this Court's assessment of prejudice, holding that what was important was the fact that the defendant had been deprived of his right to the process of getting a new trial. And that, in fact, is what this Court stated was important in Benevento.
Do you lose unless we change our law?
No, Your Honor. Under either standard in this case, counsel was effective. What is important, though, in terms of this Court's ability to state the standard, in this case, regardless of the ultimate outcome, regardless of whether this Court chooses to adopt Strickland, we would ask that at least the Court make it clear that the Appellate Division erred in not evaluating prejudice at all, and that the prejudice component is a discrete inquiry, even under the state standard, regardless how that's applied.
Well, the Appellate Division didn't say per se. It said that inasmuch as the witness's testimony went to the heart of the alibi, counsel's error undermined the defense. Doesn't that sound like a harmless error analysis?
No, Your Honor. If it was a harmless error analysis, then the Court would be evaluating the outcome, the effect on the outcome of the trial.
Well, there were two defenses presented, correct? An alibi defense and an identification defense.
Yes, Your Honor, that's correct.
Now, if each of them are credible, but one self-defeats or self-destructs because of the timing issue, doesn't that go to the heart of that one defense? And had she testified to the fact that she was with the defendant on the night of the 9th and the morning of the 10th, then it would have been a great alibi defense, wouldn't it?
Well, Your Honor, it would have been. However, she wasn't with him on that day, so she couldn't testify.
Certainly, and indeed the prosecutor, a very good prosecutor, made a great deal of that.
Yes, Your Honor.
Do you think that he or she, whoever they were, babbled on about irrelevancies to the jury because they just wanted to somehow take up some time, or do you think that they used that error, that unbelievable error by the witness, to show how bogus the total defense was, to use a term that my son would use?
Well, Your Honor, in evaluating, in your question you address both the performance and the prejudice. I'll address them separately. Okay. In evaluating counsel's performance here, counsel's decision to present the alibi that was subsequently shown to be irrelevant was a tactical decision. There is no question in this case that counsel knew that the alibi related to the wrong date, and he chose to present it. He made an informed choice. Now, regardless of the ultimate wisdom of that decision and whether or not it backfired...
When you say ultimate wisdom, how about any wisdom?
Well, Your Honor, I would argue that there was wisdom to it, because this alibi was not promulgated by this defense attorney. It was promulgated by defendant himself in the grand jury, as evidenced by the Wade hearing transcript, which is part of this record, where defendant himself testified to the wrong date, and where person, the alibi witness, also testified about the wrong date. At that time, defendant was represented by a different attorney. When this attorney came into the case, he was faced with the untenable position that he had something that had been recognized as an alibi by a prior prosecutor, two prior prosecutors, a prior defense attorney, and the hearing judge, all of whom did not notice that, in fact, the alibi applied to the wrong date. So the position that counsel was in, where he had defendant telling him, I want to present this defense, and where defendant ultimately has the choice of defense, and where he was already stuck with an incorrect alibi, was essentially to present it and hope that it'll work again and that it won't be caught.
Okay, I'll give you tactical. Let's go on to the second side.
Well, Your Honor, if you give me tactical, that's enough, because if it was a tactical decision, then this was not an effective assistance.
This is for purposes of argument.
I have to ask you this question now. I'm reading the majority decision in the appellate division. I was a little bit puzzled by asking myself, what would the majority have this lawyer do? Given the scenario and given the background, do you read this as suggesting that a lawyer should then present a perjured defense in order to get around the bed that had been made for him?
Yes, Your Honor, and that is exactly why this position is not tenable. Here the attorney did the only thing that he could do in light of the facts that he was presented with, and that was to present the defense honestly.
Let's suppose, putting apart what the bed that had been made for him in the grand jury and that had gotten by two ADAs before that, if indeed the closest thing to an alibi is a day off, do we want any more of defense lawyers than to present whatever the facts are? Do we want them to hypothesize or to fabricate something beyond that? Is that how you read the majority decision?
Well, Your Honor, I think the majority decision essentially says that either a defense attorney should present an alibi or find an alibi, or that the defense attorney should just not take the risk, period. The problem with the majority's decision is that it ignores the fact that the unique circumstances of this case were different than they had been in prior cases. Here, the defense attorney was not simply mistaken. It wasn't a blunder. It was a matter of a tactical choice. And the situation
Why do you say it was a tactical choice?
Well, Your
What
Honor,
shows that in the record?
a lot. First, the first thing is, in terms of the arguments below in the appellate division, defendant explicitly conceded, in fact, affirmatively argued on 3 occasions in his brief that this was, in fact, counsel knew that the alibi did not relate to the correct date. Second, the record shows that in this case, I think the most forcible way to show it, in looking at Lakeisha Person's testimony, when she was confronted with the fact that she was not giving an alibi for the correct date, she did not try to say, oh, that's not what I meant to say something else. She immediately recognized, yes, that's correct. I'm testifying as I was in the grand jury. That clearly shows that she was prepared for the question, and counsel is the one who prepared her
Maybe she was
for it.
just a good witness, telling the truth.
But, Your Honor, if you look at other aspects of her testimony, for instance, when she's asked about whether defendant had a striped shirt, she doesn't say, yes, he did. She says, well, lots of people have striped shirts, and she tries to find a way around it.
I want to go back very briefly to a question that Judge Wesley asked you. Let's go by, let's say there's a blunder, assuming hypothetically this was pure blunder. He didn't catch it any better than the ADAs before. You have an appellate division implication here that it was prejudicial, that it did affect the result. What do you have to say about that? Is that something we can review, or are we stuck with it?
No, Your
Or
Honor.
are you stuck with it, rather?
No, Your Honor. That is something that you can review. I recognize my time is almost up. May
I hope-
Please, yes.
Please.
In terms of prejudice in this case, there was no prejudice to defendant, regardless of whether this was a blunder or not, because essentially all that happened here is that he presented an alibi that was shown to be irrelevant. Now, the prosecutor did not affirmatively use this on summation to argue that therefore the people's case was somehow stronger. Rather, the prosecutor said, discount the alibi. In this case, that was not counsel's only defense. He also presented a misidentification defense that, importantly, was entirely separate from the alibi. It related to the complaining witness's credibility, as evidenced by his misstatements on the stand, and it related to the way that the complaining witness had described the perpetrator as opposed to defendant's actual description. So in this case, the defense itself was not harmed in any way by the alibi being shown to be irrelevant.
Thank you,
Thank
Ms.
you.
Aldea. Mr. Landau?
May it please the Court, my name is Todd Landau, counsel for Respondent Dwayne Henry. Your Honors, it is clear that defendant was deprived of effective assistance to counsel, given his attorney's thematic and indefensible presentation of false alibi. Defense counsel in his opening statement promised to raise an alibi defense. And not once but twice in his opening statement, he said this case comes down to a question of belief between the alibi witness and the complainant. During the trial's evidentiary phase, defense counsel directed the witness's attention to 24 hours after the crime had been committed. During the prosecutor's cross-examination of the alibi witness, it was clear that she testified to the wrong date and time. Defense counsel, undeterred, returned to the defense on redirect. On recross, it was painfully clear that he testified to the wrong date and time. Now, on summation, instead of saying it was my mistake, focused on the misidentification, defense counsel argued at great length, with great passion, great vigor, they established a successful alibi defense. Making matters worse, and I quote for the court, said this: she told you what she told the grand jurors. He was with her. He was there at that time. And that's what it comes down to, a question of belief, unquote. A question of belief between the alibi witness and the complainant. And its respondent's assertion as ridiculous to postulate a jury confronted with misleading alibi testimony that was permeated through it the entire trial, simply disregard that testimony when evaluating the prosecutor's sole eyewitness testimony.
Now, the defendant must have thought something of this alibi because he went into the grand jury and gave that alibi, didn't he?
Yeah.
Didn't he?
Well, I have the grand jury minutes in front of me. It's about 18 pages, and it's not really, that's how the people representing the grand jury testimony from the Wade hearing. It's not entirely clear that was a grand jury testimony.
How about Ms. Pearson? She went in there and testified.
She testified, appears, I don't have a grand jury testimony, but from the record it appears that she testified to the wrong day in the grand jury.
Isn't it conceivable, but having that occurred, that indeed the defendant took up the position that through prior counsel and through his appearance before the grand jury and his submission of witnesses before the grand jury, that the defendant himself personally believed that he had a defensive alibi?
Well, there's simply nothing on the record, and it appears from the summation counsel was just confused about the dates of the crime.
Now, if it had been the defendant's position and he'd instructed his attorney to do so, is that ineffective assistance of counsel when the attorney is merely doing what the defendant tells him to do?
Well, we would say two things to that, Your Honor. First of all, it would be based on fraud and deceit, and defense counsel should not engage in that conduct. But secondly, when the prosecutor during cross-examination of the alibi witness, when it became clear that the witness testified the wrong date and time, defense counsel at that point should have forgot about the defense and just focused on the misidentification during summation.
I don't mean to distract you, but
Sure.
let me walk this through with you. The defendant says to his attorney, I have an alibi. And the attorney says, it's a great alibi, it's the wrong day. He said, no, I have an alibi and I want an alibi defense. Now, does the attorney have an obligation to say to the court and to the prosecutor, this is a bogus defense, but I'm putting it in because I've been instructed to do so? Does he do that? Does he or she do that?
A good defense counsel, an honest defense counsel would bring it to the court.
Does the law require it?
Well, my understanding of the disciplinary rule that it's based on fraud and deceit to try to pull one over on the jury.
Did she lie? She lied. She didn't lie. She said she was with him on the 10th. It's not a lie. I'm very familiar with the disciplinary rule. The rule says you can't perpetrate a fraud on the court. Did she lie?
Okay, so
Curiously, who's now in possession of the only information of the ineffective assistance of counsel? The defendant and his attorney. You're asking the people to prove that this is a totally irrelevant, ridiculous defense. And yet, if this attorney was doing this because his client told him to do so, he's completely in control of any record evidence that would establish whether the defendant told him to do this or not, isn't he?
Right, but the people never made a 440 motion in the appellate division. They wanted this case decided on direct appeal.
So we should allow the people to inquire of the defendant's attorney every time we have these. They're all over the appellate division record now where these lousy alibi defenses. We should allow the people to interject themselves into the attorney-client relationship between a defendant and his criminal attorney as to their trial strategy?
On appeal, Your Honor, it would go from the trial division 440, go back to trial court. But even
the district attorney would have an opportunity to start a 440 proceeding to get the underlying facts as to what was instructed on this thing. Is that what you're saying?
So normally that's what they usually raise on an ineffectiveness claim. That's the first argument. They raise a 440 that there's not enough to appear on the record, and they ask for 440. That's one of their initial.
It's your position that this record clearly establishes the ineffectiveness, but you place the burden on the people to show that he was effective.
Okay, Your Honor, I understand your question. Even at the outset, even though the record's not, we would say that the record's clear because there's a summation about the confusion of dates, but we don't know exactly what occurred between defense counsel and defendant. But once it was clear that the prosecutor made clear that the witness testified the wrong date and time, and it was the defense was done with, during summations when he should abandon the alibi defense.
Okay, that's what I'm interested in. The key then for us to understand the effectiveness or ineffectiveness is to look and see whether the prosecutor, he or she, ratcheted up this error to really wipe out the defense, because that's what it does. I take it from what the appellate division said, and I would suggest that I wouldn't be surprised if you agreed. The appellate division essentially said, this guy got no defense.
Right, particularly when defense counsel says it's a question of belief, of who do you believe between the alibi witness and the complainant. When you phrase it in those terms, you're taking away you're taking the heart of the misidentification case. And we just rely on, quickly, Your Honor, we cite a case called Connor. It's a federal court case where...
Do we look at the defense attorney or at the prosecutor to determine ineffective assistance in this case?
Well, we would argue you look at the defense attorney's actions, but when it was strategically utilized by the prosecutor, it made that much more egregious and prejudicial.
So without the prosecutor, there is no ineffective assistance?
Even if the prosecutor, this court determines that the prosecutor did not strategically utilize it, but still have ineffective assistance of counsel, because defense counsel didn't abandon the non-existent alibi for summation. He continued to argue in summation at great length that he raised a successful alibi defense.
Were you citing U.S. v. Chronic? Is that the case that you just mentioned?
Connor v. Lane. Connor v. Lane.
Connor v. Lane? Is that in your brief?
Yeah, we gave you an appendix. I provided an appendix for this court. And in that case, the federal district court held that defense counsel's presentation and emphasis upon a false alibi undercut defense counsel's entire position that there was a reasonable doubt as to the identification of the defendant by the victim. There's no further questions, Your Honor.
Thank you, Mr. Landau. Ms. Aldea?
Briefly, Your Honors, just a couple of points in response to defendant's argument. The first is that in terms of this question of prejudice, defendant claims that the reason this was prejudicial is that the prosecutor strategically utilized the failed alibi on summation and that this alibi destroyed the defense because it went to the heart of the misidentification defense. Both aspects of that argument, though, are false. First, the prosecutor here did not strategically utilize it. He simply said the alibi was irrelevant.
Was that relevant that the prosecutor didn't utilize it? Don't we look to the defense attorney and what the defense attorney did?
Your Honor, in evaluating performance, yes. In evaluating prejudice, not necessarily. Because in evaluating whether the defense was prejudiced by this, you would need to look at what was before the jury, what inferences the jury might have drawn, and how it might have affected their verdict or their deliberations.
But the jury didn't need the prosecutor for that. They could look to the actions of the defense attorney.
Yes, Your Honor, they could. But the first element of that is that the prosecutor didn't strategically utilize it. The second element, though, the jury in this case, there is evidence that the jury did not simply disregard the misidentification defense. They did exactly what defense counsel told them that they should. They asked to see all of the exhibits that related to the misidentification defense. Specifically, they reevaluated the testimony of the detective relating to the lineup procedures, and so it's clear that they didn't just ignore the rest of the defense. They actually seriously considered it. And because of that, Your Honors, there can be no prejudice in this case. Additionally, it's defendant's burden to affirmatively prove prejudice. In this case, I'm going as far as taking the burden on myself and saying that the record actually shows affirmatively that there was no prejudice.
So you're saying it was harmless error, what the defense attorney did?
No, Your Honor. I'm saying that it was not prejudicial, according to this Court's standard of prejudice. It did not adversely affect defendant's right to receive a fair trial. Not because it didn't affect the outcome, although that's part of it, but also because in this case, defendant had no alibi when he started, he had no alibi when he ended. He had a misidentification defense that was presented and considered, and that's all he was entitled to have. So for these reasons, Your Honors, we respectfully request that the decision be reversed.
Thank you, Ms. Aldea.
Thank you.
Thank you, Ms. Lane.
People against